So if I show you something that is 10 lines of code, you might very well say, well, these 5 lines, there's no other way to write this, so there's no copyright protection. And these 2 lines you didn't really come up with in the first place because someone else wrote them for you, and so forth. And you might get to the point where the 10 lines, there's nothing left to protect. And so that's the sort of thing they might argue. But if there had been infringement, yeah, they would be liable. They would be liable to enormous damages because they have many, many products. And they've sold many copies. And also, it would be a public relations disaster for them, I mean, of biblical proportions. So Microsoft would be very concerned about that, and yes, there would be a way to pursue them. What was your second question?
My second question was about the genomics and biotechs. I know about cases where there has been literally a case where some biotech companies have patented genomic sequences. And I think in America the courts actually said the only thing that's not patentable is an entire human being. And so the biotech companies said that, well, we can basically patent every single part of the human gene, which already is happening properly. And so a person had to give blood to test, I don't know, something to cure him. And he just didn't have the right to give that blood to anyone else because he was...
So this is a very interesting question. So in the United States you can patent a gene sequence. So I should explain that the way this came up in the first place is that companies were actually altering gene sequences. So for instance, a very famous case has to do with laboratory mice. That they would alter the gene sequence of the mice so that they could use them for testing, say, drugs or something having to do with humans. So they would change their gene sequence so that they were better test subjects and that they would give better results as applied to humans. So the court said, yes, you can patent the gene sequence. But then the question the gentleman was raising is, does it really make sense to be able to patent the gene sequence, because we all have a gene sequence inside us, and can someone else really have the right to that? So for instance, if I give blood to someone in order to do a test for me, for my health, am I actually violating a patent? That makes no sense. And I think that's a very good point, but I don't think the law has really dealt with it yet. And I would not be surprised if sometime in the future there was considered to be some kind of right that a person has, like a personal right in their own information, their own gene sequence, that they could control. But nobody has really addressed that except in theory yet. It's a very interesting question. Most of the gene sequence patents, though, have been very small sequences having to do with laboratory experiments. But it's a very... I actually, when I was in law school, I was very interested in that question, and I wrote a paper once about whether someone should have an intellectual property right in their genes, because it's like a privacy right. You know, you have rights about your own information, because people have to control their own destiny, and the law should support that. So it's a very good question. Yes?
Yes, I have a question about open source software. I want to know how is regulated by law the authority of the open source developers, because we know that everyone has access to develop further that product.
I'm sorry, can you say the question again, because
Yes.
A little louder.
Yes, just I want to know how is regulated by law the authority of the open source developers, because we know that everyone has access and can develop further that product.
Yeah, so the question is, how does the law allow you to enforce open source licenses when anybody can have access to the software under an open source license? Open source licenses, they have some conditions to them. There are many different kinds. Some of them have very strong conditions, like the general public license has very strong conditions. It's the most popular one. But then there are others. The most famous is the Berkeley Science Division license, or the BSD license, which has In the United States, we now have case law that says you can sue based on those, but it's primarily a copyright infringement claim. It's not really a contract claim, which is sort of a technicality. But in any case, if someone uses your software that you provided under open source license, but doesn't meet the conditions, they're probably liable to you for damages. It's currently thought that injunctive relief is not going to be available, but that it's a developing topic because we have one reported case in the United States right now. So they are enforceable. I don't think there were many lawyers that were surprised by that, but many lawyers had asked, would there be injunctive relief? What would the damages be? And in the United States, by the way, for copyright, there is a type of damages that we call statutory damages. So if you can't figure out what the real damages are, there are amounts you can ask for that are sort of like estimates. And it's typically thought that under open source, that is what you would get. That ranges, by the way, it can range from $30,000 to $150,000, I think. I might be thinking of an old version of the statute. But you can ask for that even if you can show no actual damages. So that's typically what we think in the United States right now, although the law is certainly still developing in that area. We're only at the very beginning of open source enforcement. Yes?
For example, if you go and apply for the patent and they don't accept it, the government don't accept it, do you have a choice to keep it secret, or are you protected somehow?
That's a good question. So if the patent doesn't issue, can you then keep it secret, or do you have to disclose your invention? Right now, the U.S. is very different from other countries. In the U.S., a patent application is secret until one of two things happens. The patent issues, or it gets published, and it gets published 18 months after you file. So if you haven't gotten a patent within 18 months, and you don't think you will, you can withdraw it, and it will never be published. In most other countries, I think maybe in almost all other countries, the patent is published when you make the application, and you could not make that choice. So it's very different in the U.S. This is one reason. But remember I said that there's a treaty by which if you have a priority date in one country, it will be the same in another. So a lot of people think it makes sense to start prosecuting in the United States. And then if they think that the patent is going to issue, they file elsewhere because they get the same date that they filed in the United States. But in that 18-month period, they could decide not to have the patent issue. Yes?
Can you talk about the cost of filing?
Cost of filing a patent? The actual fee in the United States is $400 or so, but that's not the expensive part. The expensive part is to get a lawyer to write the patent for you. And unless you have a lawyer write it, it probably will not be very enforceable. And typical cost in the United States is, I would say, from $5,000 to $20,000, depending on how complicated it is. Now, obviously, that's not maybe the same everywhere. I just know in the U.S. I don't really know so much about it elsewhere. If you write, it makes a great deal of difference how you write a patent, how enforceable it will be. So typically, it's probably not something you want to do on your own because it just the decision to get a patent is an economic decision, and if it's not going to be enforceable, it's not worth putting money into. So it's a question of how much it costs versus what you would get out of it, and it can be very expensive. But if you want, you can file a patent on your own and pay the $400. Just not many people do that. Yeah.
What documents should you apply when you want to file an application for patents? Because I know for customer.
Mm-hmm.
I'm really want to know about U.S.
Okay, so in the U.S., what you would do is you go to a website, www.uspto.gov. That's United States Patent and Trademark Office, and all of the documents you need are on there. You can download them, PDF, whatever. It's actually a very good website. It has a lot of information. This is, by the way, the same for trademarks and copyrights in the United States. It's very easy to get the documents and information off